Hi, I'm Veronica Irwin, and I am the regulatory reporter at Unchained, and I am here with Amanda Tuminelli. Would you like to introduce yourself?
Hi, I'm Amanda Tuminelli. I'm the Chief Legal Officer at the DeFi Education Fund. We are a nonprofit, nonpartisan advocacy group. We advocate for the rights of DeFi developers and users and anyone who wants to innovate using DeFi technology.
Yeah, and I thought that we would kind of regroup after the Blockchain Association Policy Summit. We met there at the summit, and we're recording this 2 days after. And then I also wanted to talk to you a little bit about a paper that you recently co-authored that is very relevant to the Tornado Cash case, and might be of interest to our listeners. But just to start, how are you feeling recovering after the summit? What are your thoughts after it's all wrapped up?
I feel good. I think it was a really amazing group. There were some really great panels. Really, I feel like that summit really gathers the thought leaders in the space, and we discussed a huge variety of issues that are really important. I think people are hopeful, especially compared to last year's summit. The vibes were much more positive and optimistic, and that was really fun to be a part of.
Yeah, it was the first one that I've ever been to, but that's what everybody said. Everybody was like, wow, there's so much more energy here this year. People seemed definitely excited, a little bit hesitant. We'll see what happens next year, but definitely very optimistic.
Cautiously optimistic. That's how we feel at DEF. So.
Cool. So yeah, the paper that I wanted to discuss, you co-authored with Variant Funds, Jake Chervinsky and Daniel Barabender. And it was published on December 2nd, called Through the Looking Glass: Conceptualizing Control and Analyzing Criminal Liability for Unlicensed Money Transmitting Businesses under Section 1960. A lot of legalese there are involved in the paper. Just to start for our audience that might not be quite up on the topic that you're addressing here, what is Section 1960?
Sure. So that's the criminal penalty for running an unlicensed money transmitting business. So people have heard of money transmitting businesses usually in the BSA, the Bank Secrecy Act context, and that's a different part of the US code. So that's like Title 31 of the US code. We are in Title 18 of the US code, which is the criminal code. And the reason why this was so important to us to write about is because it includes criminal penalties for those that the government is saying are running unlicensed money transmitting businesses, and that could be up to 5 years in prison. It's a felony. So it's a really important topic. The stakes could not be higher. And it has been recently in everyone's minds because of the Tornado Cash and Samurai Wallet cases, where the government is putting forward a theory of Section 1960 that we think is wrong on the law and not supported by the statutory history.
You mentioned the statutory history. That's what I was just about to follow up on. What was the purpose of this when it was first written?
Sure. So years and years ago, decades ago, this was part of a money laundering statutory effort. And the only reason for encoding 1960 in law was to be a enforcement mechanism for people who did not get licenses under the BSA. This was supposed to be an enforcement mechanism. So if you didn't get a state license to be an MSB or a federal license to get an MSB, this penalized that. But when the Patriot Act was passed, they amended 1960 and added this additional provision. It's 1960 B1C. And this provision is like what we call the or otherwise provision. It covers a broad swath of conduct that is in addition to failing to get a license. And the government has been using this in the Tornado Cash case to say that really anything that they think is money transmitting, anything they think that is money transmitting falls into this B1C or otherwise provision. And the statute defines money transmitting as transferring funds on behalf of the public. And what we write about in our paper and we provide support for is to transfer funds on behalf of someone means you must take custody and have control over that person's funds. I can't transfer your funds if I don't have them to transfer, or if I don't have some way of controlling your funds to transfer them. And we think that's very obvious from even just the plain language. And we have case law to support that. But the DOJ is reading out that meaning and kind of reinventing what they think transferring means, and using ludicrous examples like saying a frying pan transfers heat in the same way that a non-custodial software protocol can transfer funds according to the DOJ. So that's what really got us, we felt it was urgent to write a paper like this, and particularly important to correct that, and make sure that there was support for that for other lawyers to use.
It makes me wonder, it seemed implied in your argument, but I'm curious if you'd be willing to address it directly, like how important decentralization is to be able to be the type of money transmitting business that you described that actually takes control of the funds before transmitting it. Like, how does decentralization play into whether a business should be covered or not covered by Section 1960?
So I'm going to reframe decentralization in terms of custody and control, and say that if you have published a software protocol and you're the developer and you publish an immutable smart contract protocol where you have no ability to change that protocol, and you're not taking custody over funds, and you are not in any way saving people's keys or have any other form of controlling their funds, you should not be considered running a money transmitting business. And the reason we know that is because in 2019, FinCEN released guidance with their interpretation of money transmitting businesses under the BSA, and said they laid out like a very similar test to what I just said, which people call the wallet test. Like, are you taking custody? Do you have control over funds? And gave guidance to the industry that the industry relied on for the past 5 years, and we thought was relatively clear. And the DOJ said in Tornado Cash that they don't even need to listen to the FinCEN 2019 guidance, and said that, because that's the BSA, that's different than 1960. So you have two branches of government coming out differently on the same set of facts.
Mm-hmm.
And, like that really offends principles of due process and fair notice, and just knowing what the law means and knowing what you can and cannot build.
Interesting. Another piece, and obviously, I should tell listeners that they should read the paper. It's over 41 pages, and there's a lot of detail I can't really get into in a quick video. But one piece that really stuck out to me was the mens rea component that you described. Can you tell our listeners just what that term means, and why it is pertinent to discussion of Section 1960 and specifically the Tornado Cash case?
Sure. So mens rea is the mental state that is required to be guilty of a crime. So when the most classic example is if you are going to be convicted of first-degree murder, that usually requires a mens rea of intent. You intended to murder somebody, you premeditated it, plotted it, planned it. That is different from homicide in many places. This is state by state, but in many places where there could be a reckless mental state in causing someone's death, where you didn't set out to do it, but like you were either negligent or you didn't think about it and you did something that would cause somebody's death. So that's a big difference in mens rea, intent versus recklessness or, conscious disregard.
Mm-hmm.
In Section 1960, right now, the court's interpretation in Tornado Cash was that you don't need to even know that there is a law requiring you to get your business licensed, and you can still violate this law. So you don't need to know that your business needs a license, and you don't need to know that 1960 punishes the failure to do so. The only thing you would need to know for knowingly in 1960 is that you don't have a license. But it's this like kind of bizarre dichotomy. Like, so I need to know I don't have a license, but I don't need to know that I need a license. It's a bizarre kind of outcome. And I think that's because the statute's been rewritten a couple of different times. And when it was originally written, there was a higher mens rea requirement, meaning the government needed to show that you did know that you need a license. And they took that out with the Patriot Act. So it's become this like Frankenstein conglomeration of different language over time. And the mens rea component has made it easier for the government to show that someone is guilty of 1960.
Yeah, that was really surprising to me, and I guess it made me think about, I wonder how many developers and engineers just in other countries where they're probably not legal experts to begin with, but especially not American law if you don't reside within the United States. how if your protocol ends up being used by Americans, you could fall into you could run into this law essentially and not even know it. It was very alarming to me reading that section of the paper.
It is alarming. That's why it's our priority right now. It is really alarming because we know about these two cases, but there are a number of ongoing non-public investigations. And, we are hopeful that the next administration is not going to continue this and is going to correct course and say the DOJ's interpretation is not accurate. But until they do that, we are, like I said, the stakes could not be higher. We're very concerned.
Mm-hmm. And I guess just to kind of wrap up, I'm wondering if you can explain just where papers like this, because this is incredibly detailed and it was definitely a great learning experience for me to read through it, where papers like this come into play with the actual lawsuit. Like, is this something that you would hope is referenced in the lawsuit, that you will reference in your own filings? How exactly do papers like this come into play with the process itself?
That's a very timely question. Last night, Roman Storm's lawyer filed a motion for reconsideration of the denial of the motion to dismiss and cited this paper and also a paper written by Matt McGuire and Jacob Hirschman at Circle. And they had also analyzed a different aspect of Section 1960. So that it was cited as of last night. But yes, we are always hoping that this helps lawyers craft their legal arguments, whether those are our own lawyers or other people's lawyers. And we set out to publish in a journal that looks pretty, that a judge might actually pick up, because we wanted it to be citable in front of courts anywhere, and provide the legal support to advocates to use that.
It's fascinating. I wish there were three of me so that I could spend like a whole full-time job just covering all of these lawsuits. The process is really interesting. Well, thank you so much for discussing this with me today. I think that's a good place to wrap it up.
Thank you so much. Thanks for covering it and being interested in it. We are hopeful that people will actually read the paper, but even if you don't read the whole thing, read the first few pages. We put a summary at the beginning, so we really appreciate people's attention to this.
Awesome. Thanks so much.
Thank you.